All right, good afternoon, folks. It's Commissioner Minas, and I'm now calling two matters again at the same time here. We're calling the matter of Dakota Mortensen and Taylor Frankie Paul, 264901444, and Taylor Frankie Paul and Dakota Mortensen, 264900189. Council appearances, please.
Brent Hall on behalf of the petitioner / respondent, depending on which case number, Your Honor, Dakota Mortensen, who's present behind me.
Good afternoon, Your Honor. Eric Swinyard with Taylor Frankie Paul. She's present with us. I also have co-counsel Ryan Ficklin in the conference room with us.
Okay, all right, very good.
Mike McDonald, guardian ad litem for the minor child.
All right, so we're back here on parent time reviews. I also wanted to, first of all, just thank the parties for mediating and at least trying. It sounds like they didn't come to a full agreement, but in as much as there's a motion to set aside the stipulation in the domestic case. And I'll just also indicate with that as well, I made an error. That shouldn't be scheduled before me. That is a potentially dispositive motion. So I think that has to go before Judge Mao. So we'll strike the hearing before me on that motion to set aside. Although further hearings, if there's further reviews, we'll do them in the domestic case. All right. That makes sense? Okay. All right. All right. Very good. So here we are today on a parent time review. And why don't I start with Mr. McDonald? I'll let you know, I've read the assessments from both parties. I've received those and read them. And I'm going to try to avoid getting into too much of the details if we possibly can during this hearing. All right. We can make reference perhaps to some of the issues and where we might be going from here. But I would really like to try to protect privacy as much as we can with respect to these assessments. All right, Mr. McDonald, why don't we start with you?
So, Your Honor, the other thing that I wanted just to make sure of is in your ruling under number 6, it talked about not making further parent time changes in this case. My recommendation is to do something slightly different than what we have been doing. So I'll make that recommendation, and I guess we'll do what we do with it. Okay. So the reason that I wanted to continue supervised parent time at the last hearing was because those assessments hadn't basically been done yet. We didn't have the results of the assessment, things of that nature. I also wasn't sure because sometimes the division does collaborative cases and they kind of get them going and then they don't track what's happening after the fact. There's two things that I think are positive in this case. One is that the assessments have been completed. I've reviewed the assessments and I think they give really good recommendations. I think that they're recommendations that if followed through are going to get at the heart of the problem. And I think I've shared this with both parties. I think that on the other end of this, everybody's going to come out the better, assuming that the recommendations are followed. So that part of it, I think I'm good with. The other part of it is the division is involved. They're going to be involved for quite some time, I understand, in terms of tracking progress on the recommendations. And that gives me some comfort in terms of safety issues because I know the caseworker, I know him quite well. I anticipate that he's going to be going out and doing home visits, both announced and unannounced, and keeping an eye on things. So my recommendation based on those two things was going to be that we move to unsupervised visits. And in moving to unsupervised visits, I think it also would be appropriate to do standard minimum parent time under the statute. I think there are a couple of things that concern me that were raised in Mr. Hall in the brief that the declaration that Mr. Hall submitted, which is, from what I understand, there hasn't been full engagement in parent time. Some have been cut short. Also, and this isn't necessarily anybody's fault, but there hasn't been like a schedule that's been followed, which I think is also difficult for my clients. So it seems like at the beginning of every week, there's a conversation about, okay, let's do it on this day from this time. And it always seems to be slightly different. I think with, a 2-year-old, it would be good to have some consistency. So I'm hoping that if we do move to standard parent time, that would give visitation a little bit more consistency. But other than that, I mean, that's my recommendation for today based on what I've said. And I'd submit otherwise.
All right. Any volunteers as to who wants to go next?
I'm happy to jump in, Your Honor.
All right, Mr. Swinyard.
All right, appreciate it. Well, I do want to, I understand the court's caution that you want us to use discretion in terms of getting into the substance of the assessments. And I have no problem with that, because what I find more concerning is what's not in the assessments, Dakota's in particular. I do want to touch briefly on Taylor's first. By her design, as you saw in the assessment, this was not a pleasant experience. She knew going in that it would be best to simply dump out everything so the assessor would understand everything, the good, bad, the ugly.
Well, that's what we hope for.
Yep.
Yeah.
And yeah, Taylor, of course, like anyone, wanted the assessor to know her side of the story about the abuse she had endured. But importantly, she also wanted the assessor to know Dakota's side of the story, Mr. McDonald's analysis of the case, evidence collected by law enforcement, the input from both law enforcement as well as prosecutors. The assessor even spoke with the DCFS caseworker, Mr. Tabusoa. So my client did not force the assessor to rely solely on her self-report. She also provided the requests for the protective order, both hers as well as Dakota's, the full police report, even audio from the hearing regarding Mr. McDonald's comments made at the previous hearing. So her mindset going into this was, this is a mental health assessment. It's not an audition. This is not a first date. It doesn't matter what Ms. Mendenhall thinks. It doesn't matter if she likes me or thinks highly of me. It's important that she knows the truth about what happens and can understand from various vantage points what's unfolded over the last 3 years between these parties. As you'll see in the assessment, as well as all of her filings and arguments throughout these cases, Your Honor, she is not completely blaming Dakota for this mess. She's taking ownership. The court can see on the final page of her assessment on page 7 what she's been recommended to undergo, and she's already in the works with that. The most significant addition, the most significant component of the treatment recommendation is participation in at least 24 sessions of trauma-focused therapy, such as EMDR therapy. She was previously seeing a therapist, but switched to one of the therapists specifically recommended by Ms. Mendenhall, the assessor. So her therapist's name is Amy Spratling. She is a licensed clinical mental health counselor. But then Dakota's, and you know, this is a tale of two assessments, Your Honor. When I first looked at it, I wondered, where's the rest of it? This only discusses Taylor and his allegations regarding her misconduct. There's no mention whatsoever regarding the court's findings against Dakota. These weren't addressed in the assessment. To our knowledge from the assessment itself, these were not even brought up. He admits to certain things, such as being a heroin and fentanyl addict, but does not touch on any of his violent conduct. In fact, on page 1, he specifically denies all area of risk. Now, I was at the April 30th hearing, Your Honor, and I see things a little bit differently here. This court specifically found that violence had occurred both ways. It's not clear if the assessor knows that a PO was entered against Dakota. This court specifically labeled Dakota as deliberative, subtle, manipulative, obsessed, and calculated. Where's that in the assessment? Also missing is what happened last May. As to that incident, the court found that violence occurred both ways, specifically finding that Dakota kicked my client while she was on the ground, while he was holding their child, leaving bruises all over her body, multiple locations, primarily on her lower body. Why wouldn't that be included in the assessment? Where's the part where he was the primary aggressor on February?
Well, it's a mental health assessment, right?
And there's supposed to be a domestic violence component to it, understanding whether he's at risk by her, sure, but also whether he has some tendencies of his own that need to be addressed. That's where my concern comes in, Your Honor.
Okay.
Also missing is him being the primary aggressor on February 23rd when he bashed my client's head against his dashboard, leaving visible bruising on her head that lasted for days. Where's the part in the assessment where he drove off that same incident, where he drove off with Taylor in the car against her will and left their 2-year-old son ever at home alone? He did not include any of this. So
I don't know that I made findings on that. I mean, as I recall, we were talking about blood gushing from the nose, but we never had any evidence of that. So really what I was basing my recommendation on was the bruising that she had suffered. So
from May, Your Honor, is that
yes,
what you're referring to?
yeah,
All right. Understood. The point remains, though. We are alarmed having read this, but also not surprised. This has been Mr. Mortensen's approach from the very beginning of this case. deny, 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 no acknowledgement or ownership whatsoever of his acts of violence. I'm going to use a metaphor. It is very imperfect, so bear with me. But let's think for a minute of their respective mental health journeys as a race. The assessment and the treatment recommendations, those are the starting gun of the race. Taylor's running down the track. She's made progress already. She's taking ownership. She's taking actual concrete steps. Dakota has not even started the race because his assessment is so one-sided and does not include anything that could, that points to his culpability in this story. And he has plenty of it. That's why in our filing from last week, you would have seen, Your Honor, that we are essentially requesting a redo of his assessment. This time, and we're not asking for anything we're not asking for anything more. She just wants Dakota to provide the same collateral information to his assessor that she provided to hers. Pretty basic, I think. He simply was not open or honest in his assessment as DCFS requested the parties be. And that's a perfect segue.
Was he? I mean, I don't know how much this is driven by the assessor too, in terms of what the questions that they're asking. They're not the same person, it doesn't look like, right?
Yeah, Your Honor, I do take issue with counsel.
Let him finish first. Let him finish first.
course.
We'll come back. We'll come to you.
So, Your Honor, a lot of the assessment is narrative, what Mr. Mortensen has reported to the assessor. And so that's what I'm basing it on. I don't see any indication that he was forthcoming. And that's what I would have expected from the court's May 6th ruling. And that's what DCFS has explicitly indicated in terms of their preference. There was a team meeting. Now I'm segueing into a few comments about where DCFS is at, Your Honor.
Right.
There was a team meeting, separate team meetings in this case due to the protective orders. A team meeting on May 27th. Both parties in this case have filed DCFS's 8-page summary of the child and family plan. And to summarize, it gives both parties a handful of items to be working on, and both sides are in progress on each item. The main exception from our perspective is that Dakota is not really undertaking the assessment in an appropriate way. So those, in terms of where things are at, I'm happy to also address some of the arguments that they've made regarding social media and missed parent time. I can do that now, or I can hold off until Mr. Hall speaks. What would you prefer, Your Honor?
Well, I'd like to know where you're going. I think I can anticipate that you're wanting a restoration of the terms of the stipulation.
Exactly right. There are a couple main allegations made in Mr. Mortensen's filing from last week. Some social media posts by my client, as well as some missed parent time. I want to address those arguments now, and then
I wanted them to be addressed as well. And I also wanted to address the allegations that maybe there was parent time that was canceled or missed.
Sure, no problem, Your Honor. As to social media first, either the court should give his arguments zero weight, or the court should give both parties some instruction regarding social media practices during this case. If we look at docket number 96, this is our supplemental briefing that was filed a few days after the hearing. This is an Instagram comment.
In which case?
This would be in the within case, in the Mortensen matter, Your Honor.
The one where he's the petitioner or the respondent?
The petitioner, Your Honor.
Okay, all right.
So again, docket number 96, final page there, that is an Instagram post made by Mr. Mortensen the day after the hearing on May 1st, where he tags our witness, Ms. Jessie Draper, and publicly ridicules her using profanity. He also mentions Taylor by name. I interpret this to be intimidation and harassment of a witness, something Taylor has not done. We think the court should be concerned about both of these women being named in his post. The integrity of the proceedings are compromised if Dakota is allowed to publicly disparage a witness who went out on a limb to provide the court with valuable information regarding the proceedings. If, for instance, after today's hearing, Dakota went on social media and used profanity to, let's hypothetically, lay into Dakota's therapist, the court should rightly be bothered by that. And so we think that this was inappropriate. There's also another leak after the April 30th hearing in which Dakota leaked a voice memo to TMZ, yet again designed to embarrass Taylor and the aforementioned witness. More media circus, more unwanted attention on the parties and their child. And to use his words from the May 28th filing, when he makes his social media argument, I actually think, ironically, this conduct on Dakota's part shows a concern regarding his mental health and impulse control. Yes, Taylor did chirp at someone online. This is a former friend who she felt diminished the terrible ordeal she has been through, especially the abuse by Dakota. But she didn't tag Dakota, didn't rip into one of his witnesses as he's done. As far as
Well,
misparenting,
did she disparage him in the postings at all?
there's, if you read the postings, she's certainly talking about her journey, and Dakota has interpreted that as being kind of indirect disparagement. But we've got this delicate balance where she wants to use discretion, but she also feels that it's an important part of her journey to document her healing, so to speak. But no, she's not directly laying into him.
Well, that's the main concern I would have. I mean,
Okay.
these are people that have effectively made their private lives public right into the thick of popular culture. And I don't want to restrain them necessarily from their rights of free speech, except to the extent that it might adversely affect the welfare of the children. So if we're talking about disparaging others, that is one thing as opposed to disparaging each other, something that the child might eventually be able to see, and it might affect the child in the long run. So as you know, we have standard types of restraining orders against making denigrating, derogatory remarks directly to or in the presence of children, dissuading third parties to do the same, and then including or in public forums, including social media. That's not an uncommon type of order that we would have. Not trying to restrict them from their right to engage in social media, but only to the extent that they may be denigrating each other.
Understood. I appreciate that additional direction. I think both of these folks will benefit from that clarification, Your Honor. As far as missed parent time is concerned, my client wants every minute she can get with her son ever. A few of the visits over the last month or so have been cut short or have not taken place, and there are a few examples or a few reasons for doing so. A recent example is the child was extremely ill. I believe it was with hand, foot, and mouth disease, which is awful.
Cold sore breakout.
A cold sore breakout.
That was addressed through counsel, right? You talked about that.
Yep. As far as Mother's Days, the Mother's Day visit, the long Mother's Day visit, that was cut a little bit short because of limited supervisor availability on that day.
Okay.
There's also some difficulties and ongoing challenges regarding just coordinating schedules with supervisor availability.
All right.
As far as our request today, you already know, Your Honor, you touched on it. We're asking for lifting of supervision as well as a return to normal custody and parent time. What was agreed to in the August 2025 stipulation. Supervision is not designed to be permanent. It's appropriate to lift it now because safety concerns have ebbed and are being addressed in a comprehensive way with both parties. Remember, there's safety concerns with both parties, and both parties are currently addressing those with DCFS. Really cannot describe at all how difficult it's been for both my client as well as Ever to endure this separation over the last 2.5 months. Not to mention Ever's two older siblings. These are two children that my client shares with her ex-husband, Mr. Paul. We have 3 extremely confused, hurt children who need to be back with each other. She successfully co-parents with her ex-husband, shares custody of the 2 other children. And again, the sporadic and very short visits have been difficult on all 3 of them. This child, Ever specifically, does not understand why this is happening, why these visits end so abruptly. And she's in a difficult situation where, again, abruptly ending these visits has been extremely challenging for Ever. And so she has a decision of moving forward, hell or high water, with every single visit, no matter what, knowing that they may be traumatic for the child or unduly difficult for the child, depending on the day, or hold off on some of the visits, knowing that Dakota will use that against her and try to portray her as unmotivated or disinterested. But that's just not the case here. Ever is her entire life. She's been his primary historical caretaker almost his entire life. They signed, as Your Honor already knows, a comprehensive settlement agreement in August that awarded most of the time with Ever to my client, about a 70-30 split, roughly. Mm-hmm. There was a brief interruption last fall when my client was filming The Bachelorette with ABC, and Dakota did have, during that period, more time than what was allotted in the agreement. It was a temporary period. Since the April hearing, my client has purchased a home. She has plenty of space for her and the 3 kids. This signals stability on her part, stability that all of her kids, including Ever, will benefit from. On the other hand, it's not really clear how or if Mr. Mortensen can provide for Ever. He's not currently working. He labeled himself as a stay-at-home dad in his assessment. We're not aware if he has any income. It says he used to own and operate a tile business. Not really
I
sure.
think he filed a financial declaration in the domestic case, right?
And I don't have that in front of me, Your Honor. I'm just going from what I think is even more recent, the assessment, where he reports financial information in that to the assessor. Mr. Mortensen, aside from having kind of a black box when it comes to income, he has nowhere near the same support network in Utah that Taylor has. He rents his home. His roommate is a bit of a red flag. He has a couple of, this individual, Crew Eaton, has a couple of past criminal charges. This is the same person who walked out of the courthouse on April 30th and called the court's decision a joke and pathetic. My client is not a danger to Ever. The court has already entered an order of protection against both parties, protecting them from the other. And we think that going one step further and blocking my client from Ever, or a functional equivalent of blocking her from Ever, is unnecessary. An additional concern is that she's been in the dark regarding her child, including who's watching him at any given time. She'd simply like to know who's watching him right now. She'd like an order that the parties notify the other of the identities of any third party who watches the child. And we believe that that is a very small request. But again, Your Honor, we are at a stage in the case where we have a lot more information than we did a month ago on April 30th. The mental health professionals have weighed in. They weighed in for Taylor, and I think there's a huge caveat in the extent to which they've been able to weigh in for Dakota, given his inability to be forthcoming. We also have ongoing participation with DCFS. DCFS has mapped out their plan, their vision for the case, which has a lot of overlap with the recommendations from Ms. Mendenhall, my client's mental health assessor. And so we think at this point, the waters are calm and there's a lot of good direction that my client is taken seriously. And so we think that it is appropriate to not only lift supervision, but re-implement the parties' August settlement agreement.
All right. And I'm also looking through the domestic case. I don't believe there's financial declarations from either party. So, all right. Okay. All right. Mr. Hall.
Yes, Your Honor. What I hear is a lot of speculation about things that they're guessing on the other side. I think the easiest one to address first is the evaluation, Your Honor. It's my understanding that the division took part in that evaluation, that Mr. Hiram's his first name, that he actually spoke to the evaluator, gave the collateral information, shared. My client has accepted fully what the division has tagged him with, which is failure to protect. Not domestic violence, Your Honor, failure to protect. He had
But I made a finding, though, about domestic violence.
You did, which is what we also made sure that the evaluator is aware of. I think to make this easy is, in full, openness, I've had my client's therapist appear, Your Honor. She's one of the attendees. If you want to bring her in, she's happy to talk to you about his progress in therapy and where she's at. And that's Miss Patty Martinez. And she has spoken at length with the division on this case. The division was provided a copy of this eval quite a while ago. We've had child and family team meetings on it. It's satisfied the division, and we're moving forward with what we need to do, Your Honor.
Well, the recommendation was in weekly individual trauma-focused psychotherapy. I guess it said to address symptoms of post-traumatic stress disorder, and it should include EMDR and/or trauma-informed CBT interventions, psychoeducation regarding domestic violence, trauma bonding, coercive control, etc.
Yes.
Okay.
And I have his therapist who's been conducting that here. They've had multiple sessions, and she's happy to answer any questions the court may have about that, Your Honor.
Well, we're gonna do a proffer hearing today. All right.
That's fine. Okay. Just letting you know, she can jump in if you need it. But I would proffer her testimony saying that she's spoken both to the evaluator and to the division and confirmed that the evaluator had full collateral input from the division. It's a valid eval, Your Honor. I just think we have a situation where there's an annoyance that his problems aren't as heavy as the moms. And I think this court's pretty clear from the mountain of evidence. My client's a victim of domestic violence. That's very clear. He had an incident, as you ruled, where he may have crossed the line, as this court ruled, in terms of self-defense, but it was an incident. You've seen the video. He was assaulted first. And so he was trying to do his best for it. I think, learning about how to stop that and be a better parent would be great. But I have a hard time kind of understanding where she says she's doing more, mainly because as part of the parenting classes that were recommended through the division, we gave you that, he has decided to go a step further. Instead of just do parenting with his therapist or a Love and Logic, he's decided to get the gold standard, Your Honor. That's the Children's Center. And that's parent-child therapy, or PCIT. And they call it something else now, but it's the same thing. He signed up with that about 2 weeks ago. And unfortunately, they're still waiting for mom to accept and approve. And so in essence, she is blocking him from getting further training, which I think is a concern, Your Honor, of why she would even feel empowered to do that, or why. And that doesn't make sense to me. I think
Who's blocking who from further?
The mom is blocking dad from getting treatment at the Children's Center.
How so?
Because the Children's Center says they need permission from both parents to engage in therapy with the child.
Well, are we talking about individual therapy, or are we
This
talking
is
about
parent-child therapy, Your Honor.
conjoint
It would be
therapeutic?
conjoint therapy with the child and the dad.
Why would we do that? We're talking about a 2-year-old.
Because they actually have the best for toddlers is parent-child interaction therapy. Teaches you hands-on skills of how to deal with a therapist in your ear, with everything you need to do for parenting and everything else.
You're talking about parenting skills more than anything else then? Or
Yes, but it's also therapeutic knowledge, developmental knowledge. I'm sure Mr. McDonald can bring you up to speed as well if you don't want to hear my biased approach of it, but it's the gold standard. If this is in direct controvert to what they're saying, that he's trying to run from this. He's actually trying to do more, and she's stopping him, which I think is very interesting, Your Honor, because it shows where he's trying to recover from this and be a better dad for his son. I think that's important. Speaking on that,
the
Your
court
Honor,
can certainly issue an order that bypasses
yes,
the consent requirement if that's where
that's-
you're headed.
that is my request. If the court needs, I can draft an order. I just assumed it would have been done 2 weeks ago. I sent an email to counsel saying, hey, we need this. Your client's going to be contacted. So there we are. I do have to take issue with several of the facts, Your Honor. One, I know it's interesting. We keep hearing, oh, she's accepted all of her bad and it's him that hasn't. I don't really hear acceptance. I hear he's the abuser, and we see it online all the time. And she has made directly derogatory. It's in the file I gave, Your Honor. She actually says psychological torture and show pictures of bruises. Dakota ruined their son's birthday. This is after the April 30th hearing. Thank you, Taylor Mortensen, for help today. Aside from his name, everything was perfect. Disparaging the name of her own child. She's making accusations that he's caused miscarriages, that he's beat her. These are things the court's never found, and we vehemently deny and say that this is just an attempt to put herself in a better light. This is not as simple as she's accepted and he hasn't gotten there. If anything, he's done the furthest to get where he needs to do. He's probably, I don't know. I'm not going to speak to how many sessions she's had. That's her business. But he's done many, as Patty Martinez can explain. He's worked on his issues. And that's, I think, the most important thing. And remember, our main issue here is failure to protect. If they're apart, they're apart. He has a 6,000 square foot house that he's renting.
Is this more an issue for the custody and parent time issues in the domestic case?
Of course,
right.
but
mainly what I was contemplating today, that we'd be addressing whether to lift supervision, 1, and 2, what the parent time arrangement should look like on an interim basis. And we do need to get a private guardian ad litem in the domestic case as well.
I was going to ask for that as well, Your Honor, but we still have that issue of the stipulation floating out there. I do need to mention, Your Honor, the stipulation is very clear, and it contains a full non-disparagement clause involving social media as well. That has been consistently violated, and I do have to say violated as it wasn't a court order. And I know I'm moving to set it aside, but it's an agreement between the parties, which they're harping on in terms of, oh, we should go back to that, but we still have problems following it. And I do think it's important, Your Honor, because it shows it isn't over. It shows that we have some mental health challenges on the other side. And that was
I didn't expect that everything would be completely resolved by
I
today.
figured as much, Your Honor.
It's going to be a process over time.
As we put in our motion, we are fine with lifting supervision as long as the guardian is okay with it. He's indicated he's okay with that. We still have concerns about that. We're worried about who's actually providing the care when she's there. We're worried about, her kind of posting everything on her phone and doing everything instead of parenting. But you know what? We do have the division involved. We do have Hiram checking in on the case. I think there's enough that we can have that support, and it has been a challenge in terms of scheduling. But we do want to continue with the status quo of care, which has been provided. This course sees fit to go to standard. It's one way to handle it. But right now it's 12 hours, and you specifically wanted 3 separate sessions. That was your order. She demurred and said, no, I can only handle 2. And of course, she says it's for Ever's
I
benefit.
think I said
We all know-
up to.
Up
Didn't I
to.
say? Yeah.
Great, but if it was me or my client, we'd be taking every single ounce of parent time we could, and that, just as you can see, hasn't happened. And I know there's excuses for it and other things, but it's still a concern. He also provided quite a bit of care. I mean, if you look at it, they were together for the first, 5 months of this child's life. That's direct care. Then we take, since the August stipulation, she was gone for almost all of October, November, and December. Well, half of October and December. And she had maybe, as I put in there, a handful of time with the kid. Since then, he's had much more than his allotted time. This is a child that's essentially being raised by dad. And that's great. And we're happy to move forward and get mom on board. We really do want her on board. We think that's important. But
I guess
status
it's-
quo is primary care.
I guess it still begs the question with the knowledge that he had after the criminal matter,
Mhm.
there was still an agreement that he entered into that she would have the majority of the parent time. And I don't know that I've ever been clear on why he went down that road.
Well, Your Honor, I think that's one of the crux of why we're in therapy and why we had a failure to protect, is that he was not in maybe the best mental health position to say, I'm going to fight her for this, and knowing that he'd probably get more time anyway, which is what's been happening. But now we're in a situation where orders matter, so we need to move forward with those. I do want to clear up that his house is appropriate. The roommate's in a mother-in-law separate appointment. I believe Mr. McDonald set his investigator out there just the other day, checked it out. The division's gone out there and checked it out. Completely appropriate. There are no crimes on the roommate. I take issue with that. I looked up the record. There's, I think from 9 years ago, a dismissed case. And from, I believe, 8 years ago, an infraction for setting off fireworks. That's it. That's all they're bringing. And that is not a problem for the
What's
division
his
or
name?
anything else. It is Crew Eaton, but the first name is, I believe, Timothy. I had to look it up that way.
And Eaton, E-A-T-O-N?
E-A-T-O-N. You're welcome to look, Your Honor.
Okay, anything else?
I think what's important here is the things I really wanted is we're okay with allowing unsupervised as long as as long as the division's okay with it, which it sounds like they are. Mr. McDonald's okay with it as the guardian. I do think we need a private guardian ad litem in this case to continue monitoring. I know that your order will last until September 27th. It's our intent, depending on what happens with the stipulation, to file motion for temporary orders so that we can move this case along. We're probably looking at a custody evaluation and a private guardian, as the court indicated. This is a healing case, Your Honor. I think the best way to keep it healing is to make sure that we continue things the way they are. If we want to make it easier by going to standard parent time, well, I don't think we're going to argue with the guardian on that, but I think it's critical that we continue to have the continuum of care that he's had for many months, actually more than half his life, if you look at the actual months that he's had the kid. And then what's really important is we do want that order, if you're comfortable giving it today, to allow him to progress with the Children's Center, which is the gold standard for toddlers to make things better, Your Honor. I think that pretty much covers it, unless the court has any further questions. Did you have?
I've asked the questions. I think maybe we want to go maybe one more round of rebuttal, and then I'll go back to the guardian ad litem before making a ruling.
Sure. Thank you, Your Honor. I'll touch on the PCIT first. This was framed as something that they found out about a couple weeks ago, and we've just been sitting twiddling our thumbs. I want to point out, we did not receive documentation that PCIT was recommended until approximately 1 week ago. But from Dakota's representation just a moment ago, he went ahead and started scheduling this 2 weeks ago. I believe was approximately what his attorney said. So
Does she have any objection to that going forward with that?
our concern with it, Your Honor, is that contrary to what he represented through counsel 1 week ago, this was not the division's recommendation. It was a recommendation that came through his assessment. And then the division said, okay, fine, I guess you can do it.
Okay.
That's not accurate, Your Honor.
Like I said, we'll do another round of rebuttal. I just want to get through this one at a time.
The first time we heard of PCIT was when Mr. Hall emailed our office and said, given the division's recommendations, my client has contacted the Children's Justice Center. So it was clearly implied to us that this came from DCFS. DCFS later denied that and said, no, it was in father's assessment. The same assessment that we have massive problems with that we think needs to be redone. Our perspective on PCIT, first of all, we're not even sure how necessary it is with a 2-year-old.
What harm do you see that could possibly come to it?
What harm?
Yeah, what's the potential harm? I mean, I don't know that I've ever been involved where, in a matter where there was a argument against therapeutic intervention, other than costs.
Sure.
Right.
Your Honor, at this point,
in terms of it potentially causing damage.
Sure. I don't know that there's any risk of it causing damage, to answer your question. We would prefer that it come from a legitimate assessment, which we don't have right now. That's our main issue. So if it's ordered today, she'll comply with it. If it comes down from Dakota's from a redone assessment, a valid assessment where he is open and forthcoming, then she'll comply with it. But right now, there's a lot on both of these folks' plates, and we think that it would be, we think it needs to be demonstrated first in an assessment before they go down this road.
All right.
As far as the scope of today's hearing, there's been a couple comments, Your Honor, of, hey, we're just here to maybe tweak parent time. Maybe the court has discretion under its May 6th order to bump this up to standard minimum. Maybe not. No, the court specifically said that we're here today to evaluate a longer term time sharing plan. That is within the scope of today's hearing. And so the request for reinstatement of the parties' agreement is certainly within the scope. Counsel argues that Mr. Tabusoa was a party, he was consulted in Mr. Mortensen's assessment. That's just contradicted by the assessment. I don't see Mr. Tabusoa listed anywhere in here. In fact, page 1, it says participants, client only, meaning Mr. Mortensen only. So no, I don't see anything that indicates there was actual input from collateral parties, nowhere near to the extent anyway, as we saw in Taylor's. As far as where things are at, I mean, his argument today underscores a lot of our concerns. He again says, well, as it relates to May 2025, he may have crossed the line. I mean, this court found that he was holding the party's child and kicked my client while she was on the floor, and this was not self-defense. No, that's not crossing the line. That's domestic violence. He assaulted her. He kicked her and left visible bruising that lasted for several days. I mean, kind of done with these arguments. And this is his tactic from the beginning of the case. Deny, deny, deny. I walk on water. Taylor is the devil. That is his entire tactic in approaching this. And it doesn't do him any good. It doesn't do the parties any good whatsoever if he takes the same approach, if he carries this mindset into his mental health journey that has not truly started yet. So today, again, we are not asking for anything novel whatsoever. We're asking for reinstatement of the parties' settlement agreement. The agreement that Mr. Mortensen signed not even a year ago, saying, yep, it's in my son's best interest that this woman, that Taylor, have the majority of time with our child. So we're asking for that today, Your Honor. Thank you.
All right. Mr. Hall, let's go to you next. I still want to go back to the guardian ad litem about the argument about the legitimacy of of your client's assessment. Well, any rebuttal from what Mr. Swinyer just indicated?
First of all, I mean, you're reading an eval. I can read hers as well, Your Honor. And there's quite a bit of information in there that I believe shows the severity of the problem. You indicated you didn't want me to cover it, but if you look at the risk assessment, you're welcome to take a look. As to my client's assessment, I have his therapist, Patty Martinez, here, and I would proffer her testimony today, and she's in the attendees if you wish, that she personally asked the assessor if she had spoken with Mr. Tapasoa. The answer is yes. I have sent this to the division quite a while ago, asked if there's anything else they need. I have not heard any response. In fact, we've had response. We've had child and family team meetings, Your Honor, and I do have to disagree. I did see that email, but the division is the one that recommended the parenting course. And at the child and family team meeting that they weren't involved in, but we were told parent-child interaction therapy is the best way to do that parenting course. It's the gold standard. Normally, I have a cost problem. In this case, Your Honor, I think it's the way to go. So this isn't an invented thing. And frankly, the fact that someone is opposed, a mom is opposed to a dad getting hands-on training with a therapist on how best to handle a toddler, that just floors me, Your Honor. And I think it shows kind of the problem here, that it's kind of this, image thing rather than what's working best for the parties. This assessment is full and complete, covers all of his issues. I think it sounds like they're just disappointed that it didn't recommend more. I mean, yes, this court found that he engaged in self-defense that didn't count as self-defense. I will again remind
That's not what I found. I found that he committed an act of domestic violence.
We argued it was self-defense. The court said no, and that's understandable, and he's taken responsibility for that. But Your Honor, we're struggling with the possibility that we've had multiple incidents committed by Ms. Paul against him again and again involving children. And especially in that very incident, he was struck before that even happened. The idea that he's the only abuser is something I don't think we can really handle.
I didn't say he's the only abuser.
I'm not saying it. I'm hearing it from counsel. Yeah. But I think it's important that they both follow this journey. This was billed as a domestic violence and full mental health assessment. Like I said, I have Ms. Martinez here who's been working with him, who can happily tell you about how far it's gone and where she feels the assessment's at. We have the division who's looked at it with no problems. I think this is nitpicking, Your Honor, as a way of trying to get kind of the spotlight turned to him rather than where are we at with mom, who we have consistent problems, making the parent time, consistent problems with, continuing to derogatory and tell further stories of abuse that were never presented to this court or anywhere else, criminal or otherwise, and still happening on social media, even though we have a stip that they want to return to that says they were never supposed to do that. So I do think we have a new circumstance here, Your Honor. I think we need to continue with the guardian's recommendation, and we do support that, of following the parent time schedule the guardian wants. Let's move along. We have further things to do in this case. We'll likely get full psychologicals done in a custody eval, but for now, let's keep things the way they are until we can brief this for a full temporary orders hearing, Your Honor.
Okay. All right. Thank you. Mr. McDonald.
Your Honor, just to address the PCIT thing first, I talked to the division's caseworker about this earlier today. I think, first of all, PCIT is a form of therapy that is geared towards the child and then sort of coaching the parent. So the parent interacts with the child. Generally, they have like an earphone in, they have the therapist in the room kind of coaching them on how to do things. Initially, he did not make the recommendation for PCIT therapy, but some of the information about the difficulty with exchanges, the tantrums that have come up, and things of that nature is, according to Mr. Tapasoa, what led him to make that recommendation. He's actually recommending that Mr. Mortensen participate in PCIT, and he's also recommending that Ms. Paul participate in PCIT. So it's a recommendation that's going towards both parents. My understanding is that, and this is again coming from him, is that Ms. Paul.
Well, did he evaluate Ms. Paul? Can he make a recommendation with respect to Ms. Paul if he hasn't interviewed her?
Well, so this is the caseworker, so he's not the therapist.
The caseworker, okay.
Correct.
Right.
Yeah.
Okay.
Yeah. So Mr. Tapasoa is the caseworker, and it's not in the child and family plan for the reason.
Not the assessor either, right?
No. The assessor didn't recommend PCIT for Ms. Paul.
Okay.
This is more a recommendation that's coming from the DCFS caseworker that's geared towards some of the issues that they've seen with Ever going through all of this. So I think that that's the goal, and I think that what he wants is for both parents to work on that. My understanding is that Ms. Paul hasn't made a decision yet. and that she's talked about being overwhelmed and things of that nature. So they're giving her a little bit of time. But I do think that it's an expectation
For a little
of the
bit of time
division,
on what?
for her to come to a willingness to engage in PCIT therapy.
Oh.
Yeah.
All right. Well,
That's the division's expectation with their case and what they want to see happen. What they want to see happen. So that's the PCIT issue. I think the court wanted me to weigh in on Mr. Mortensen's assessment. You know, I don't know who the assessors talked to or didn't talk to. Obviously, in Ms. Paul's assessment, the assessor laid out very specifically what she did and who she talked to. That section doesn't seem to be present in Mr. Mortensen's evaluation, but that doesn't mean that he didn't talk to folks. My understanding in talking to Mr. Tapusoa is that he doesn't have any issues with Mr. Mortensen's assessment, and he would like to see him follow through with the recommendations. I would note that in Mr. Mortensen's assessment, one of the recommendations is to, as you've noted, engage in trauma-specific psychotherapeutic treatment, and specifically it mentioned EMDR, which is what I think is going to happen. I would note that in Ms. Paul's assessment, it actually specifically says evidence-based therapy to treat PTSD symptoms. This is actually a higher level of care than domestic violence treatment and should be considered as part of the recommendations. So I'm frankly satisfied with both assessments and both recommendations, and I just hope the parents will follow through. I think finally, the court made a comment at the last hearing that I forgot to touch on, but the comment was that the parties really need to kind of focus on themselves and fixing their own problems rather than focus on each other and what each other are doing or not doing. And I think that that would be a helpful way for these folks to move forward in this case. In speaking with Mr. Tapusoa in the division, I think that they feel the same way. I think that's what needs to happen.
okay. All right. All right. Let me go ahead and make some recommendations. Well, I think that when we first came into court today, when I heard from the guardian ad litem at first, that was pretty much in line with the same kind of thinking that I had walking into the hearing here today. I was prepared to be lifting supervision today based on my reading of the assessments as well. There may be some things that could have been brought up, some issues that could have been raised perhaps by Mr. Mortensen in the course of his assessment, but I'm not sure that he had to, that would have been an expectation of him going in. I think these assessments, while they are largely based on self-reporting, are also driven by the therapist as we go through this. And I think there's a lot of information in the assessment that shows that he was focused on certainly some of his own issues. And it was mentioned the substance abuse issues in the past, which were, quite frankly, would have been a real concern if this were 3 years ago, perhaps. But we're here today, and there really haven't been allegations that currently he's suffering from those kinds of substance abuse issues that he did in the past. It may be a lifelong process there as well. I did also mention at the prior hearing that I was inclined to take baby steps, and the question arose when Mr. Swinyard, when your declaration, the updated memorandum as to why she was supervised and not him, and I have to say I've given that a lot of thought, and because if this were a case where, say, it was only a finding against Mr. Mortensen for domestic violence, it's conceivable that he may have been supervised as an outcome too. I think as I thought about it more, part of the reasoning was that we had a situation where there was already a criminal case where there were that Ms. Paul had gone through, and she'd already been ordered through treatment, and then there was this subsequent incident that also had taken place. And so there was a real concern about whether anything had been learned from that first experience. I mean, that was a felony charge that she had gone through, and yet there was this other incident. And that may be what was driving that. And it certainly, before we had the hearing where I made the recommendation for mutual orders, that's the information. That's really the only information I had at that point. When we were talking about the ex parte order, and then we were coming back, we had set it over, had additional time, came back before we had the actual hearing on the merits. So lifting supervision is certainly part of the order. I also, though, want to make a recommendation in addition, and I think this should also get into this order should also be put into the domestic matter as well, that the parties should be following the recommendations of the DCFS. And if that includes PCIT or EMDR, then that should be part of it. I think that that's important. So if there are any releases that are needed to make that happen, I want the parties to execute those releases. Otherwise, I may be back here making a Rule 70 order authorizing the clerk of the court or authorizing one party authorizing the clerk of the court to sign on behalf of a parent if that's what the therapist requires, or just simply allowing each parent to engage in that on their own without the consent of the other party. But I want them to execute those releases. And then let's see here, those consent forms as they may be. So stay in treatment. That's another part of the recommendations, to stay in the individual therapy. They should all have a domestic violence component to the therapeutic process. And I didn't really get the impression that looking at the assessment either that Mr. Mortensen was taking the position, as was represented, that he walks on water and she's the devil incarnate. That's just not the impression that I'm getting. I certainly do think that both of them have a sense that they are the victims and not the perpetrators. And I get that. I think that that's not unexpected. I think what my main concern is over time, as we've talked about in the past, is having the dust settled from the fallout that that came when these matters were both filed. And it may be that no matter what we do, we won't be able to change their opinions that they have of each other. But the main concern of the court is to prevent further acts of domestic violence. And if we can have the hope that someday we can have a child that can see the parents in the same place getting along with each other, that would be great. But now it's not that time. It definitely has been my concern, and it has been my belief that I could keep them away from each other, at least now, until there could be some measure or demonstration of increased maturity along those lines, where they can be in the same place at the same time without it turning ugly fairly quickly. That would be certainly a long-term hope, but I think we're also a long ways away from that. And as was mentioned too, there is in the stipulation that was entered into, there's now a motion to set that aside. But regardless, I would want the provision regarding a restraint on making disparaging remarks against each other to also have that be a part of this order today. So it becomes something that's enforceable. So now we're getting into the area of what should we do about parent time. And I did indicate, as I just said, too, that at a previous hearing, I was inclined to take some baby steps for those reasons that I also indicated about why she had ended up supervised, but not him. So really, where I'm not inclined to go all the way back to the terms of the stipulation. But really, what I'm weighing is whether I should go a little bit more than what the statutory minimum provides. I do have some concerns about maybe why parent time was awarded but not exercised. But there also was some explanation about that in terms of availability of the supervisor. If we don't have supervised parent time, then we don't have that issue arising as to whether or not parent time needs to be cut short. For example, if there's no supervisor available. There is certainly a dispute about who's been the primary caretaker of this child from infancy until now. And I didn't think there was really much of a dispute that there was at least a period where Ms. Paul was away because she was involved in filming of the reality TV series that she was involved in. Although it was my impression too that at some point both of them may have been involved in the reality TV aspect as well. I think that what I'm going to do, I think we need to get a private guardian ad litem in on the domestic case. I'm inclined to set it for a review in the domestic matter. And I want to give the parties today's Tuesday. Why don't we say till Friday, the end of a work day on Friday, to see if they can't stipulate as to who a private guardian ad litem should be. I don't get the sense that we're talking about a pro bono private guardian ad litem. But I also don't have financial declarations in the domestic case to make a determination about how those costs should be allocated. So I'd like those in the domestic file as well by the end of day Friday. So then when we come back next week, I can take a look at it next week. Well, I'll just come in and do a paper review on that and make a determination. Hopefully you can come to some agreement on who that private guardian should be. If not, then why don't we have a new statute now that talks about those kinds of how we go about the selection process when it comes to custody evaluators and therapeutic intervention. Why don't we just apply that to the selection of a private guardian ad litem as well? If you can't come to an agreement, look at that new statute in terms of how selection is made. It's basically the same kind of thing we've been doing all along. Some of it's implicit that's now been made explicit by statute. Submit 3 names. If you have any objections to any particular person, state the reasons why, if there's conflicts, for example. And then the court can make that selection. I'm hoping we're getting to a point where they can start making some agreements between themselves. I know they went to mediation and didn't come to an agreement, although I'm grateful that at least they're trying in that respect. So from now until the next hearing, and we'll get you a date now before we leave, I'm going to recommend that supervision be lifted. I'll recommend parent time pursuant to Utah Code 81-9-302, and that would mean that Ms. Paul can select the midweek day on that, and then she can have the entire alternating weekends and one midweek day that's not overnight each week. And but we want that day to be consistent, so that we are on a set schedule, that everybody knows what they have the same expectations as to where the child is supposed to be, same time, same place. I'm trying to recall what we did about exchanges, how they were to occur. Were we using third parties to do the exchanges for them?
Third
We were,
parties,
Your
that's
Honor.
correct.
Okay.
We do
All
have, the guardian has recommended, Mr. McDonald has recommended a coordinator. I don't know if that would work for the exchange, but I think we could use that coordinator in the event of any concerns.
The coordinator wouldn't work for the exchange because she's not in the state of Utah.
What was the coordinator's role then?
So the coordinator, who never really got into playing her role, was basically going to coordinate the parent time each week. And then
The scheduling?
Yeah, correct. And then what was happening is the supervisor was sort of facilitating the exchange, if I remember, in a Harmon's parking lot.
Well, the statute really does permit a parent to designate an individual who's known to the other party and who the child is familiar with, as long as the parent will be back. That's just for exchange purposes. I want the parent to be available. I don't want the parents to be sending somebody to do parent time exchanges on behalf of a parent when that parent's not going to be there as soon as the exchange is complete. All right. They still have to stay 100 feet away from each other, but the intent is that if third parties are doing the exchanges on their behalf, that once that person who's retrieving the child gets back to the residence where the parent is, that the parent will be there, so they'll be exercising their time. All right. Am I missing anything here or is there any need for clarification?
Your Honor, by which date would you like my client to elect her extended parent time for the summer?
Well, I wasn't there yet on extended summer parent time. I was really mainly talking about the issue. I think she can make an election, and then let's see what we have as an available date. And I think we can discuss extended parent time at the next hearing as well. When I talked about 81-9-302, I was mainly considering the weekly schedule. I think we can throw in holidays though in there as well. July 6th. July 6th at 2 o'clock.
If I can check my calendar, hang on. That day I've got a couple conflicts, Your Honor. If we could pick another day that week, that would be better for me.
Did you hear that? July 8th at
I
2.
believe I heard 2 o'clock. That works for me.
Yeah. Mr. Swinyard?
That works for us.
All right.
And I understand that hearing will be in the domestic matter.
Yes. And that is, let me go back here. Yes. 25490-3375.
So, Your Honor, you had alluded to more than the minimum today. Is that something that is?
Well, I was contemplating it, but in the end, I'm following the recommendations of the guardian ad litem on this for today.
Your
So
Honor,
that's
if I may
something that's
ask,
within the scope of the review hearing, as I understand it.
What is that?
You'll be considering further expansion at the review hearing. I understand.
Yes,
I
and
assume that's one of the-
and also extended summer parent time as well.
All right.
and then Your Honor,
You may have I don't know if you'll have a decision by then on the motion to set aside.
it was scheduled
Like,
before Your
we have
Honor
to
on-
strike, we're striking that hearing on my calendar, and you have to contact Judge Mao's team and get that scheduled with him.
Your Honor, I'm wondering if the guardian has any recommendations of how we ramp up to that, or is a ramp up necessary? It will be this weekend, next weekend, just so that we can avoid any kind of discussion on that between the
It
parties.
wasn't my intention to do a ramp up. It was just to have it begin.
So,
All right.
And I
Would we
believe the
start-
statute contemplates it's the first weekend following the order. So we would plan.
It does.
on-
Yeah. Yeah. That was my intent.
We'll talk with our client and.
But I'll just indicate that we'll have Dakota be considered the custodial parent for the holidays for now. Okay? And that's not to mention that's for no other reason than we have to have one, we have to just know which holidays each of them will be entitled to.
Understood. And Your Honor, there was,
And the holidays will be pursuant to the 302 statute.
Your Honor, both sides separately mentioned a concern during argument today of wanting to know which third parties are caring for the child. Can the court, it's almost like we're talking past each other, but there'd be a stipulation on that point. And so I would ask for an order that the parties let the other know the identity of any third parties and responsible for caring for the child.
That was my intent. Oh, you mean third parties caring for the child?
Like for right now, for instance, right? If we know that a parent is not
Or
taking-
doing the exchanges?
well, both.
I don't know. I hadn't thought about that.
my client would stipulate, Your Honor, if we want to get a stipulation that each party inform each other. I think that's following the advisory guidelines, that each party inform the other of who's providing care. That's fine.
But we're not doing a first right of refusal right now either.
No, just
Understood.
information.
Right.
Could-
Information purpose. I'm fine with that. Yeah.
Could counsel just inform us who's watching the child right now?
You know, why don't you take that offline? I'm
Yeah,
fine, but yeah.
I get the answer.
Okay.
Just contact each other after the hearing, make those disclosures. All right?
Okay.
Thank you, Your Honor.
All right. And who's going to draft the order from today's hearing?
That was my next question. Unlike the protective orders, I assume you want one of us to do it rather than the court?
Right. I'm not issuing a new protective order
Understood.
today. All we're doing is entering parent time orders that I want to be filed in the domestic case.
I'll volunteer, Your Honor.
All right. Thank you, Mr. Hall. All right. We'll see everybody again on July 8th. And I think we're moving in the right direction. I just want to say that I'm encouraged and I think we're moving in the right direction.
Thank you, Your Honor. Just one last request pertaining to that third-party question. Can you instruct counsel to notify us by end of business today who's caring for the child?
Yeah, I think you're being a bit pushy about this, Mr. Swinyard, but that's fine. Okay.
Crystal help.
All right.
Okay, thank you, Your Honor.
All right. Thank you. All right. Parties are excused.
Thank you.
Court will be adjourned for the day.